So, Sibbal, the only problem is, I mean, I just looking at it from this point of view, the basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in the. Which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaj? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaj. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your lordships, now the speaker will decide. This is not constitutionally permissible. Your lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaj? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsiveness to the query that your lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Millers. You lose the membership, you don't become a minister, you have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your lordship, Millers, I don't have to say anything more. My political experience and your judicial experience, Millers, we have reduced ourselves to that we are mocked. People don't believe us anymore. Anyway, so we are not against the floor test, we're against the considerations on the basis of which the floor test was ordered. This court cannot say that you cannot decide or I give 10 more days or 10, 15 days. That's not the power, that's not the function of the court. Now 5 judges have said that. Therefore, Millers, that order on the 27th put us in a situation, Millers, where the elected government was toppled. So, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue. And there cannot be any Kitamek order. Even in Shivraj Chauhan, your lordship said, because there was no interdiction there. So the court said, in Shivraj Chauhan, the speaker could easily disqualify. But in this case, what happened? The speaker could not move. So how does Shivraj Chauhan, an authority for the proposition that a floor test is necessary in these circumstances? Mullahs, when Bomai was decided, and Mullahs, Bomai set aside orders under Article 356, Mullahs. What did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. I'll show those Mullahs when I come to that. Bomai said so. Shivraj Chauhan also said so. We're not asking your lordship that what Bomai said was the acts that have happened in between can be validated by the court. Right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Mullahs was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand Mullahs when this court restored the chief minister Mullahs by setting aside the order of the governor. So we are not saying, Mullahs, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your lordships decide one way or the other. So this argument, Mullahs, that is according to an argument of frustration. Because you are now saying, look, subsequent events have happened, I am the chief minister, I am enjoying the fruits of power, please don't do anything. Now there is confidence in me in the House, all irrelevant. Bomai says so. How much more eloquent can the court be on this matter? Well, what's the point, Millets, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? It is respectfully submitted that governor does not have the power to invite a leader of a faction of a legislative party, acting dehors the political party. But where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the election commission, the leader is as communicated to the election commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Millets. Now he's accepting it, representing the rival faction which ought to be recognized as a political party. Now, this is the cat is out of the bag. Now he's saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself. What political party? I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities, and to prevent acts which would amount to disqualification. That's the whole purpose. Whereas the Constitution doesn't recognize that. Even whereas the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule, because he wanted to prevent acts of disqualification, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I am a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. The decision of the legislature party has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Now, your lordships will remember, all this happened much before the matter went to the election commission, because there they moved on 19th July. So, all this is so per se unconstitutional. Now come to right to dissent. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution, not in any other context, and it was rejected. And 105 of the Constitution, I'll just quickly read it to your lordships. It says, subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of Parliament, there shall be freedom of speech in Parliament. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. This court is distrustful of that, is what Kyoto says. Now, disloyalty is for a price which has secured him the chief ministership. If I can put it, differently. And this particular litigation is a shining example of that political declaration. We should, we think, defer to the legislature's wisdom and perception. Saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. Haimal actually mentioned it yesterday. Every act of theirs from the 21st onwards is an act in violation of 21A. Every act of theirs, which is undisputed. 21B, of course, but that's afterwards. But whatever may be the consequence, that disqualification has already happened. Even if the Election Commission's order is right, which is ex facie wrong, but we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification. And they did not address your lordships on this at all. The only thing they gave was that document which I showed to your lordships yesterday.
Only one thing which they have said about VPs, that they have referred to the disqualification rules.
Yes. Oh yes, I have to deal with that.
Perhaps you may want.
I'm sorry, I should.
Related to 3.1.
I'm going to show that immediately, but that's my mistake. I should have, in my desire to finish quickly, kindly go to those disqualification rules. There is compilation, Malaj.
Rule you will have.
Yes, statute compilation. Thank you, Malaj, for reminding me. I should have dealt with it.
We have some doubts, so.
Yes.
Yes.
Malaj, definition of leader. Your ladyship has it, my lord has it?
Yes, we have it.
Leader in relation to a legislature party means a member of the party. Leader in relation to a legislature party means a member of the party, chosen by it as its leader. Chosen by the party as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, Malaj. And includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, Malaj, with all my contentions. That this is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made, how could they whip act outside the house? Amalas, what were they doing in Assam? Appointing a whip outside the house? They made a serious argument yesterday. This is a whip, how could they do it outside the house? So you're sitting in Assam in the lap of the BJP and you are displacing a whip which is recognized by the political party and conveyed to the speaker, and these office bearers are there on the record of the register of the assembly. And you say Gogavle is the whip? I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Well, kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party.